Below, may I mention item number 9, Passover for a week,
Passover
for a week.
for the week. Okay, Passover
Obli-
for the week. On the prayer of counsel for the petitioner.
Yes, on
Yes.
behalf of Petitara, Council for the Petition.
Yes.
Obligation.
May I please, my lord? My lord, I beg to mention item number 2 on behalf of petitioner counsel, Mr. Disoki.
Hmm.
My lord, the matter may be taken up after 1 week. Mr. Disoki is not well.
Okay. Adjourn. Yes, yes.
Obliged.
May I please, Lordship? Lordship, I would like to mention item number 10, Lordship. This is fixed for today, Lordship, but I deeply apologize, Lordship. Paper book could not be traced out, so Lordship, it may be fixed day after tomorrow. I've already
Honestly, if
Taken
you
the
fix it, will it be possible? We'll give a try, let us see. There.
Lordship, deeply obliged, Lordship.
May I, Your Lordship?
Yes.
Your Lordship, I beg to mention item number 6.
Item number,
6, Your Lordship. The conducting council for respondent number 4 is,
what remains in this appeal?
Your Lordship,
What remains in this appeal? There was an interim order. Then interim order was stayed by this court. Then there was an IA for vacation of the interim order in the DB. Then it is said that learned single judge will proceed, however, decline to vacate the interim order. We'll close it, being influx first. All questions will be open before the learned DB. Okay, I'll pass this on.
much obliged, yeah.
Yes, what is this?
May please, Your Lordship.
Yes.
This, Lordship.
What was your, you were a respondent in the writ petition?
No, Lordship. I was not made as
How
a
can you maintain this appeal?
Lordship. Whatever this is,
Just tell us without leave. Are you aggrieved by their decision, earlier decision, which he has challenged?
Lordship, yes.
Huh?
Because,
If yes, have you filed a writ petition?
no, Lordship.
Then
Because,
how this writ appeal is maintainable?
because the, actually, Lordship, I will take your
You
Lordship.
give us these two answers first.
Yes, yes, Lordship.
Were you a respondent in the writ petition?
No, I am not.
No,
responding.
you
Yes.
are not.
No,
You were not aggrieved by any action, so you have not preferred any writ petition. And in the division bench judgment, it says that a principle is laid down. It
Yes.
not said that he will be appointed.
yes.
So how it is maintainable how it is maintainable by at your behest?
Lordship, first point that actually I am the meritorious than the writ petitioner.
So have you approached
Yes,
this
yes,
court?
yes.
So there nothing remains.
No, then Lordship, then as per the result sheet,
We
in
cannot
the note-
entertain fence sitters.
no, because Lordship,
You are a fence sitter.
yes,
If you
Lordship,
are not aggrieved, somebody being aggrieved approached the single bench. There was a relief granted to him.
yes,
Now, if you are aggrieved by that action, file a review of the judgment that I was not a party, I am a necessary party. You are even not a necessary party in the writ petition.
Lordship,
You approach the
at the
required
relevant
review.
time, because I am presumed that as per result sheet in the note, it is given there, 3 posts return back for next recruitment quota. So it is reflected in the
that's-
result sheet.
that's
So
why
I
we-
presume,
That's
Lord-
why we have said that these people are called fence sitters.
Lordship, that
They
is
are
the,
watching the game, sitting in the fence.
no, Lordship, I,
Fence sitters are not entertained. You don't have any. What is? See, never. 69, IA 47. You prefer the leave,
Yes, Lordship.
or you say that, we are saying that you have not preferred the leave.
No,
Huh?
I prefer the leave law.
But there is no IA in mind. No.
You could have pointed out
Huh.
Yes,
that leave has already granted.
yes, leave was already granted by IA
You
number.
could have pointed it out.
Yes, sir.
I'm asking
At the very
repeatedly.
outset, yes.
No.
Yes, now tell us. How can you grant you relief?
Yes, Lordship, because regarding the delay of filing this writ appeal, Lordship,
Hmm.
because I was not made as a necessary party in the writ petition,
No,
Lordship.
no, what was the grievance?
Grievances is in page 34. I was
The
presumed-
petitioner and you are having the same grievance,
Yes, Lordship.
isn't it?
Yes, Lordship.
Now,
Because-
the petitioner approached this court,
No,
saying that this act ought to have been applied in the selection process. The learned single just said, yes, this act ought to have been applied, therefore remanded the matter and come to the impugned judgment.
yes.
What is the direction?
Direction is the
Page 116, my lord. And one,
First, A and B is not relevant. Kindly come to, because of his, yes, now what's we should do? What is
Well-
your prayer in this writ appeal?
writ appeal, Lordship,
To set aside the judgment. Suppose we
No.
suppose we set aside the judgment. We allow this writ appeal. Judgment is set aside. How do you get benefit from out of it? We allow this appeal today itself. Writ petition is allowed, judgment is set aside.
yes, Lordship, my prayer is to direct the
How can
opponent to
you-
consider
how
my
can
case
you read
because-
in a writ appeal without knowing what is your grievance, without respondents being given a time. You don't have any locus to prefer an appeal, though leave has been granted. Because they have not objected, APSC has not objected.
because
See, we are allowing your appeal today, right now. What can we do? We can set aside the judgment. And kindly come to page. What is the direction regarding
lord-
his selection?
117, my lord.
No, that there are certain direction at paragraph
Let us start from 117.
2022, 23, paragraph 23.
My lord. Paragraph 23.
in
So
result,
there is a direction of the
Yes.
result of the petitioner,
My lord.
isn't it?
yes,
My
Lord.
lord. Petitioner is found to be correct.
Okay. Upon declaration or notification of the petitioner presently thereby recommending the appointment of petitioner to post of the commissioner and secretary declaring the result, there may be change in result.
Yes,
Now, my lord, result of the petitioner in respect of his candidate for the post of assistant. And during read proceeding, my lord, nowhere they have stated that there is any other PPWD candidate, my lord.
Okay.
My lord, their contention is that the PWD post reserved for a PST candidate, not for general
That
PWD.
we understand.
My lord,
But suppose there are some similarly situated person like you.
My-
You.
Lord.
So he can also be considered in that case.
yes,
That is his case.
my lord.
yes,
He says that if we go by this judgment, you are not the beneficiary. He is the beneficiary
Yes.
because he has secured more marks.
My-
For that party, he will to file a review. Saying that this cannot be. Principle of law is fine,
yes,
but the fact that you are the more meritorious candidate,
yes,
we are not brought on record by them.
yes,
So
Lord.
bring on a record file and review. How can a writ appeal allow these things? Yes, APSC, what you say? We cannot shut our eyes that some meritorious candidate will be deprived for non bringing certain facts before the court. And it is all your mistake. You have filed writ appeal. How can you give a relief in writ appeal?
Earlier, I filed
You
a
have
writ.
not even approached the courts.
Lordship, I am staying in a just far away state, so because I was not
That
aware.
cannot
And
be a ground.
as per
If
the-
you not
as-
ascertain your
as-
right,
as per this notification also, as learned brother says that it was, APCS says that it, reserved for the PW candidate, it was returned back to, so next, it will carry forward next one. So I was presumed that it is a reserve for APCS category lordship. That's why I remained, but as soon as, of course, only after declaration
you
of
don't have any
the.
grievance. Now, when you have known that, oh, this is the director in favor of so and so, I am more meritorious than him. Let me have the cream of that judgment. Isn't it? So these people are called fence sitter. Yes, who is meritorious? Yes, who is meritorious? More Okay, hard learned counsel for the petitioner admit this appeal.
No, my lord, may I submit my lord,
Admit this appeal.
lordship. There are judgment, my lord of God, my lord, regarding
Yes.
fence sitter, my lord. To the 1/8/19, my lord, the result notification was.
No, that's correct.
Yes.
My lord.
So that's correct, but.
On last occasion, when the delay was,
We'll give him a liberty to file review. What should-
now, my lord, my lord, on last occasion, your lordship was pleased to condone the delay, my lord.
File a review.
All right.
We'll pass this order.
Yeah, yes, Lord. Obliged.
We'll relegate him to file a review.
Review petition. Most of. Obliged. All right.
Yes, dispose of.
May I please, your lordships?
Yes, nobody will respond to the report.
Not yet. In fact,
No, but is it not necessary?
we were supposed to be furnished a report, but we have not been furnished yet.
What you say?
That judicial inquiry report.
This was a direction.
Yes, my lord. But then it has not been furnished to us.
Okay,
I
this
think
was
that
on
report was directly sent to the registry, my lord.
26/2023.
Yes.
Okay, we'll ask the registry to,
Or I can give a copy, my lord. I have a,
you have a copy?
Yes, I can
give a copy.
no issue. my
Okay.
lord. I can give it to you.
Madam, do we have already received the copy of the madam, required inquiry report submitted by the
Okay.
madam, the inquiry officer,
It
madam?
is submitted that the learned counsel for the petitioner has not received a copy of the report of the judicial inquiry conducted pursuant to order of this court.
Yes, ma'am.
The learned counsel submits that the state shall be furnished to the learned counsel for the petitioner within a period of 2 days from today. Accordingly, matters stands adjourned. In the meantime, the parties may respond to the judicial inquiry report by filing their affidavit.
Madam, sorry, my lord, we have already received a copy of the inquiry report submitted by the inquiry officer, my lord. We are under process for filing affidavit to that report, madam.
Okay, okay, that is what in the
My-
meantime you can find.
Yes.
List of the,
Your lordship, we have filed our status reports, your lordship.
okay,
SIT and
Ah.
your lordship.
we will not go today. It's,
Do
let the have the affidavit also on all this
After 2 weeks, maybe.
list, on when,
After 2 weeks, or date may be fixed. my lord.
as you wish, I will don't do
That may not be fixed, my lord. We all are local advocates, my lord. After 2 weeks, any that, madam, no issue.
Okay, otherwise here is considered listed after 2 weeks.
After 2
After 2 weeks.
Obliged.
Deeply obliged.
Please, this matter before a bench without one of us within bracket. A,
Oh, this is.
Without one or two.
Office note dated 17. Huh? Item 7.
So in this matters, the service report is awaited on respondent number
That's
8
right,
and 9.
that's right, that's right. 8 to 9, what to do? A notice is sent on 17/10.
Because there was a holiday, puja, holiday.
So therefore, let us wait for some
I think
time.
the affidavit by the government side is also necessary.
My lord, we are at the process for filing affidavit.
Okay.
How long?
Within a period of my lord, 6 weeks, we'll file the
It
affidavit.
will be 4 weeks.
Notice to the respondent number 7 and 8. 8 and 9
8.
were issued on 17/10/2023. Full stop. Await service report and list this matter after 4 weeks. In the meantime, the other respondents who are represented by the learned councils shall file their counter.
So we'll kindly give a date
Okay, list this matter on
after 4 weeks.
Last water complaint.
13th or
14th
14th of December?
14th of December.
14th of December. There's an interim order that will continue.
Interim order pass earlier shall continue till then.
Deeply obliged.
Deeply obliged.
Item number 8, my lord, I may have given at least 1 week, my lord. We were supposed to file reply to that.
What reply? There was this application for extension.
Yes, my
That
lord.
period is over. Now give us the.
Let him.
Yes, yes,
have
yes.
Some time, my lord.
Huh?
By then, our process.
Who has filed?
No, in
this
fact,
application? Filed this application.
But department.
You
The
have
department
filed
filed.
Why are you seeking?
Yes, my lord.
Eva,
This has become influx.
Yes, my lord.
Because you sought time for 3 weeks.
Yes, my lord.
no, let him have some time, my lord.
And you came before this court before that 3 weeks
Yes,
expired.
my lord.
Yes.
Now this court says that, okay, 3 weeks are not yet expired, so
Yes.
wait for some time.
Yes.
Now, not only that 3 weeks is gone, he has taken time for further 4 or 6 weeks for filing affidavit.
Yes.
Now he wants time today also.
Let it be, my lord, after,
So this has become infectious.
after,
We'll say this has become.
No.
Yeah, yes, my lord.
after 18,
No,
it will become.
No, in fact, they intentionally, they don't want.
Just now you sought time.
Yes, my lord. My lord, unfortunately, I couldn't locate my file. So that's what I didn't bring up. That was the problem, my lord.
Let it be.
But in fact, intentionally, they don't want to
On 18 it will
execute
be
or
over.
comply the order, my lord. That is the only, that's why they filed the IE, my lord.
18 November, my lord, the matter will become infectious, my lord.
Okay, this matter on the prayer of the learned council for the opposite party, list this matter on 18.
After 18, but
After it, give a date.
obliged.
Nothing survives in this item.
Yes, my lord.
I admit to that.
Of life,
Give a date. 19.
date may be given, my lord. Okay. May I plead, your lordships, my lord, this matter relates to the constitutional and functioning of State Human Rights Commission. The PI,
Already constituted.
but then it's not yet, it is yet to function. The chairperson has been appointed. One of the member has been appointed. Now 2 members are there, 1 member and 1 chairperson, but it's still not functioning because office they have allocated, but they are not able to provide the stationaries, even the chair, even the peon. So this commission is working without peon, without even the support staffs. And it is unfortunate. One of the
What is it?
one of the commission member has to go and even the cleaning. This is the situation, my lord.
I think my friend has gone beyond my lord facts, my lord. My lord, only post has been sanctioned, but as per the act, only the problem lies, my lord. It has to be on deputation, my lord. So last time it was advertised, no one came, my lord. Again, we are going to, my lord, advertise this here. Now, so per member,
As per that, all to be on deputation, no permanent member.
yes, my lord, that's what
And
act
who
says,
will
my
come to this office,
my lord.
more particularly in Arunachal.
Yes, so per my chairman and member, my lord.
Until and unless land acquisition is involved, construction of road is involved.
My lord,
Who else is-
my lord, so per commission, because my lord started functioning, my lord. Now we have 1 chairman, one member, my lord. Now he says, my lord, there is no chair
Yes,
table.
you
for-
are having chairman but no chairs.
No, that's wrong. For group the staff, my lord, already file has been processed, my lord. I am told that within couple of weeks it will be procured, my lord. Requisition has been sent to the finance department.
No,
As far as the
it
accord,
has
my lord,
been
it
since
will
long
be
time. my lord.
procured, my lord. Because supply of table chair, it won't take much time, my lord. Only the financial approval is required, my lord.
Not only supply, my lord,
Then-
even the support staffs, which is also another
Yes, sir.
big problem.
You are
Sanction
saying
procedure
that
already there.
advertisement, when advertisement was issued, okay.
Advertisement.
The present public interest litigation is filed alleging that Human Rights Commission in the state of Arunachal Pradesh has not yet been set up. During the course of the proceeding, it is court of the proceeding, it is submitted at the bar that already
My lord, 31st, my lord,
already the chairman of the Human Rights Commission
and one
has-
member.
and one member has already been appointed.
Yes, my lord.
Rented or permanent, rented
No,
accommodation.
my lord, it's a government building, my lord. They
A
haven't given-
government building
Yes.
has also been provided to for functioning of the State Human Rights Commission.
Right, my lord.
However, the learned counsel for the petitioner alleges that still due to lack of support staff and other infrastructure facilities, the commission has not been able to start functioning. To stop. The Learned State Council shall apprise this court on the next date fixed regarding the proposed, the Learned State Council also submits that due to difficulties in procuring employees as the act itself mandates for appointment through only deputation
Deputation, my lord.
only, comma, the government has not been able to fill up the vacancies. However, he further submits that the state authorities are taking the due measures so that the Human Rights Commission starts functioning. Full stop. In view of such submission, let the state authorities file an affidavit giving the timeline how they are proposing to make the Human Rights Commission function.
As on that, my lord, two additional affidavit we have filed, my lord.
Now, if you file an affidavit on what, how you are doing that, this the deputation is there, you advertise, you got on record, we may give some alternative. also.
Yeah.
Yes, my lord.
You file that?
Yes, my lord, we'll annex that advertisement.
You annex that advertisement, what is your problem, give detail.
Yes, yes.
In short, you give so that we will have to have an alternative.
Right.
They-
So, yes,
After
after, my lord,
2 weeks.
3 weeks.
Three
my
weeks.
lord.
I would pray to adjourn the matter. Item number 2 for tomorrow and item number 25 for after 2 weeks.
No, nothing is for tomorrow. Two we can dismiss right now. You file 482. Anyway, after a week.
Okay, after,
25 when?
after 2 weeks,
Okay, both after 2 weeks.
both after 2 weeks. Okay, much obliged.
We are on the program. Yes.
My lord, may I mention item number 3? My lord, I am seeking for adjournment for 3 weeks.
Yes, health department has filed affidavit.
Not yet. I'm not aware of it.
Huh?
I'm mentioning on behalf of the petitioner.
We understand, but you seek a salary. You say that you are working at different hospitals. You are not getting salary. Health department has not filed affidavit. They will take an adjournment. Why should you? Yes.
I'm on behalf of the animal. We have already filed an
Where is that? You have filed an affidavit. Okay, file a reply.
obliged.
The learned counsel for the petitioner, praise for and is granted.
After 3 weeks.
3 weeks time to file a reply to the counter affidavit filed by the health department. Yes.
My lord, may I mention item number 26, passport ADA, item number 26. Pass over for ADA,
What? A day. It will be next week.
obliged.
May I please, Lordship?
Yes.
Lordship, on behalf of the Lordship, Standing Council Education, Lordship, I beg to mention item number 7, Lordship. May be listed next week, Lordship.
Okay, same education.
And
Counter,
Lordship,
counter for education.
Lordship, two more, Lordship, beg to mention item number 21 and
Just
22.
a minute, let us first complete 7.
Okay.
Seven is education counter affidavit. Yes, next item number. Next
Item number 21 and 22, Lordship.
20. Why
Here,
this
here, Lordship, we have to
why
file,
these matters are listed
Lordship, here we have to file affidavit in opposition, Lordship.
by respondent number,
Respondent number, Lordship, Education Department, Lordship.
education.
And Lordship, we are waiting for instruction from the department,
21,
Lordship.
22, same.
Lordship,
Okay, interim order to continue.
and Lordship, item number 22 may be listed after 4 weeks.
4 weeks, both 4 weeks, interim order in 21 shall continue until further orders.
Dear Lordship.
Yes.
May I please, my lord, I beg to mention item number 15, my lord.
Item number
15,
15,
yes, my lord.
yes.
I am for the private respondent number 4.
You want to file affidavit or what?
Yes, my lord. 4 weeks time may be given.
Respondent number,
4.
respondent number 4, 4 weeks.
Deeply open.
May I Lordship?
Hmm.
I like to mention unlisted method,
What is the method about?
urgency of transfer and posting.
Transfer from where to where and when?
Just instruct me, senior was.
That cannot be, unless that cannot be like this. You make an unlisted mention when there is an urgency. At least you must know what is the post, transfer from which place to which place, when the transfer order is issued. Make a mention tomorrow or it will automatically come tomorrow. Yes. 2006, which judgment?
My lord,
Yes, want to withdraw? Or pursue? Tell us.
my lord,
On last occasion you wanted to withdraw, we gave you a chance.
my lord, in my understanding, since FIR is pending before State Vigilance Police and the CBI. So in my humble understanding, a Balwar court, magistrate court has.
No, magistrate court meaning here, special judge is having all the power of magistrate. So you'll have to file, that's why I said, you'll have to file the application before the special judge. Okay, so he's having the power, all the power of magistrate. Since it's a CBI and a case under special acts, okay?
Yes.
So then only it can be granted. Okay?
Then my lord, I may be allowed to withdraw with liberty to
Okay,
file.
the petitioner submits that he may be allowed to withdraw the present application and to approach the appropriate authority for redressal of his grievances, including the redressal of his grievances for non-registration of FIR by the Director Central Bureau of Investigation. Okay, I'll give a provision at under section 156. Where is the provision to go to the magistrate? Under section 156(3) of the CRPC. Prayer is allowed. Considered prisoner wants to withdraw the present petition with the liberty to approach the appropriate forum. Under section 156 within bracket 3 of the CRPC. Prayer is allowed and the leave sought for is granted. That is the
Obliged.
competent authority.
Wait, Your Lordship. The land compensation matter, my lord, they are not responding.
What is your grievance?
My lord, my land was not assessed properly. Initially, my lord, the alignment was subsequently changed, affecting my land. Now, my lord, they have assessed something, then around 9 lakhs, even they have, that also they have not paid.
File an affidavit, let us see. At least,
That
and
9
third
lakhs-
is allegation, if you want to raise a dispute, you can very well raise it, but at least file it.
Even the admitted amount also they have not paid.
Pay the admitted amount. Okay, we are for that, today we are adjourning it. Uh,
3 weeks.
Huh? When? You file an affidavit that he is entitled for this or not. Suppose you say that he is not entitled. Then will really, he will have his alternative. Suppose you admit that yes, this is his assessment, new assessment. We cannot go beyond that, beyond your admitted amount. We cannot reassess sitting here. At best take that stand. If you admit that yes, there was a realignment, there is a reassessment, and this is the additional amount. That up to that extent we can go, not beyond that. The learned counsel for the respondent, all respondents.
And not all the respondents.
Is granted the last chance to file affidavit in opposition, counter affidavit. Full stop. It is, in the meantime, there shall not be a bar to make payment the compensation amount which according to the respondents, the petitioner is entitled. Full stop. Yes, madam,
Lordship, we have filed a affidavit.
you are the deputy commissioner.
Yes,
You are helpless. Or
Yes,
what?
Lord.
Huh?
They are not cooperating, Lord.
They are not cooperating.
Yes, Lord.
Where is that statement?
It's in, corresponding number 4, page number, 4. my lord.
ESC
Yes,
or the
Lord.
deputy commissioner?
Yes, my lord.
Page 4. Yes, what is your response to this? You have not participated.
Your Honor, I think I am coming in.
Last manner or what? You will have to respond to it, or you have not received any affidavit.
Your Honor, I am for the petitioner. So Your
You are
Honor,
for the petitioners, they makes a statement that yes, inquiry, deputy commissioner says that I asked the EAC to have the inquiry.
yes, sir.
And due to non-submission of report, I could not proceed. Now the EAC comes and files an affidavit and says that yes, I started the inquiry report, I went, you were called, you have not attended the proceeding, so I could not file the affidavit. Now you'll have to reply. Until unless you reply to it, we will assume that this is correct. Then we'll dismiss your petition.
Your Honor, respondent 1 and 2 not yet filed a reply.
So that is not very important. Important is that you file an application before the deputy commissioner. Deputy commissioner relegated it to the EAC. Yes, your grievances are redressed. Okay, I'll have an inquiry report from the EAC. That is your grievance that there should be an inquiry report. Now you get the inquiry report.
Yes, Your Honor.
Enquiry was conducted. ESC says, I have done the enquiry, but he himself is not present. How can I file a report? Let him file a report saying this is that, therefore I close it. That should be the report.
Your Honor, short date may be given.
You could have filed, instead of filing this affidavit, you could have filed this report. Then Deputy Commissioner could have said, okay, without his participation, I cannot take a decision, dismissed. Instead of filing this affidavit, the PSC could have given this affidavit as a report.
Yes, Your Honor.
The learned counsel for the petitioner prays for and is granted 3 weeks time to file the reply to the affidavit filed by the respondent number
3 and 4.
3 and 4. Full stop. In the meantime, the respondent ESC, respondent number 4,
Yes.
may file his report.
Yes, most obliged. May I plead my lord?
This is a challenge to the member of the Electricity Regulatory Commission. Leadings are otherwise complete, and the person has already joined long back. So perhaps, my lord, your lordship may admit it for hearing.
This is one, selected number 1. He is having
Yes.
experience. And other one is not having experience.
Yes, my lord.
Yes, Advocate General says we should admit it and fix it for.
Or if your lordship wants to hear it, I am ready.
My lord, it may be heard and disposed of, my
That's
lord.
easy, so it can be hard and your Advocate
Then,
General has already eaten up all the times. So,
No, in fact, we also try to dispose in many occasions, but then because of maybe other sites, they took the time. That's how it has proceeded. So I will pray that your lordship may try to dispose this matter
when? Next week?
this week. If not today, then
If we take up today, or if we fix it.
I'm
in
ready, my
the
lord.
hearing, You are ready,
Yes,
but bad case, no? Mr. Chakraborty is having bad case. So that's why I'm not taking it up. It's a bad case in my view. For him, for you. It's a good case for petition.
so, my lord,
I
My-
told, na, Mr. Advocate General has eaten up all the rest of the times.
Public Service Commission.
Public Service Commission.
my lord, they are delaying, my lord.
We will have to write a judgment. And I'm trying to finish it.
And the other matter is also there, that veterinary.
Today I will finish it. That is done. We can upload it today.
Then, my lord, it can be fixed in this week.
This
Maybe
week it will
not-
not be possible.
Otherwise, I'm ready because
Last week,
it has been keep delayed and it's better for them. More, we want
Yeah,
that matter can be disposed on marriage.
I am otherwise ready. If your lordship does not take it up, in that case, let it, the other matter has been fixed on 4th of December. Let it be also fixed on 4th of December.
No, it will be a delay, my lord.
Your case is that Supreme Court has said what is the clause. It should not only be a lawyer, it should be a experienced lawyer.
Experience.
Or
Subject
having qualification of a High Court judge.
High Court
And
judge.
he is not.
District judge.
Huh?
District judge.
And he is not having that.
No,
Huh?
that is not his case.
He has no experience.
Facts are like this.
We have already shown the documents in our petition. As per the comparative statement, no experience. Only say that I enroll in that on that day, that much. And that is one. Another is the, my lord, as per the electricity rules, section 85 clause says that
Now tell us, what is your ground for challenge?
my ground is that the list paper
Prepared by the selection committee, we placed the serial number 1.
one, my lord.
Are you having the selection records?
Not today only.
That will require how they have compared and.
No, I have enclosed the comparative statement.
Mm.
We have enclosed the comparative statement.
And then on what basis you have been placed at 1?
One, my lord, my understanding is that it is three committee, my lord. The chairperson was headed by Honorable Mr. Justice C.R. Sharma. And then second member was the chief commissioner.
That we have seen.
Yes.
So they have recommended your name.
Yes, my lord. But now a question is that experience counts here, my lord. Petitioner has more than 10 years of experience. He has got experience of many district
No,
courts.
that we cannot decide. The selection committee has decided in your favor.
Yes, my lord. Number one.
Then
Then what happened is that the government went sent for the approval, but then they have chosen the number two without any reason. There is no any reason to show that how number two has been chosen. Whereas as per even the Supreme Court judgment always says substantial practice of law, because this commission member has to do lots of legal work.
what is the reason of selecting
No
two?
reason. That's also the grounds that we are submitting, my lord.
Yes,
No reason, my lord.
The very
They are
found-
saying that one is that
foundation- Very foundation is fallacious because the statute says that there will be a selection committee. The selection committee will undertake an exercise of selecting and it will.
We're just having a bird's eye view whether we can right now decide it.
My lord.
Yes.
So the statute says that the selection committee, after undertaking the selection process, will recommend a panel, not a merit list, a panel of 2 persons.
Okay.
And out of that panel, the government has been conferred with the discretion of picking up one for appointment.
That is-
Now that selection by the selection committee is not even under challenge, which means he has accepted the selection of 2. And when a panel is recommended, one name has to be at 1, the other has to be at 2. It is not a merit list. So his claim is because his name finds place, he is treating it while making the challenge, he is treating it
As a select list.
as a select list, not as a panel. And the requirement under the statute is a panel. So out of the 2, after deliberations, number 2 has been picked up and appointed. So what is his case? There is no legal right that has been violated. So the statute is very clear. If your lordship takes up the statute for a moment, my lord, Electricity Act.
my lord, statutory, my lord, may see
Section 85 first.
85(4) may see, my lord. Selection committee has to finalize. It is clear. There is no ambiguity, and that's in the statute, my lord. Section 85(4).
Electricity Act 2003.
85(3), I will just 3 talks about the finalization of the members, my lord. 3. 85(3) says, may I read, my lord? The selection committee shall finalize the selection of the
Electricity Act
chairperson.
2003.
Yes, ma'am.
84.
85-4.
85-4.
85(4) is talking about the recommendation,
Okay.
and 83 talks about the finalization by the selection committee, my lord. May I read, my lord? Selection committee shall finalize the selection of chairperson and member within the 3 months from the date of such and such reference is made to it. And second 4, their submission is on 4. Recommendations shall be the selection committee shall recommend a panel of 2 names for every vacancy referred to it.
Panel of 2. And now if your lordship sees, comes back to 82-5.
Finalize the selection of chairperson and member within 3 months from date on which reference is made to it.
Yes, ma'am.
Now can we read in isolation of rule 4? Rule 3 we cannot, sub-rule 3 we cannot, subsection 3 we cannot read in isolation of subsection 4.
4. It has to be a panel of 2.
Panel of 2.
And that panel.
But thing
Just
is,
a minute. Just this is a prima facie.
yes, my lord.
And out of that panel, under 82-5, if your lordship comes to 82-5, whatever is the recommendation, the chairperson and the members of the state commission shall be appointed by the state government on the recommendation of a selection committee.
Where section?
82-5. So out of this panel recommended by the selection committee, as per 82-5, the government will appoint 1. So his entire foundation is, your lordship will have to read 85-4 instead of panel, it has to be read as a select list. Otherwise, and there is no scope.
No scope.
So therefore, the very foundation is fallacious.
Correct.
So-
My view was that how can a selection be, because these are the,
It is like APSC selection. A panel is recommended. Out of the panel, the government has the discretion to not picking up anyone.
Apart from that, my lord, there is an order to take up the issue of utility. I
Why?
have raised the question that he is otherwise not qualified. Because if the lordship takes up section 84, which prescribes the qualification for appointment of chairperson and member, then your lordship may come to 83. The chairperson or any other member of the state commission shall not hold any other office.
Will not go to all this.
My,
Why necessary? Challenge his participation.
My-
I am saying, and while
You are having some weakness, that's why you are raising all these points.
I will address on the merit also.
You address on the merit, will not take up that. We'll say that this is, we reject this.
My lord, in answering my lord, lordship.
my lord,
In this,
not
my
be
lord, I
anything.
have, on the issue of maintainability, I am not on what point he is raising. But when he raised the issue of maintainability, another very dangerous thing has come up. He raised an issue of maintainability on the basis of 84(3), saying that he is gainfully employed somewhere else. So therefore, he could not have participated. He is disqualified under 84. And therefore, at the instance of a petitioner who is not qualified, he could not maintain that is the
Yes.
point of maintainability he has taken. But while answering that maintainability question in the affidavit, the petitioner has done a very dangerous thing. He has manipulated official records in his affidavit.
no, that is
And
the wrong.
he has gone to
that
the
is-
extent of making of
This is serious.
That's something which you are.
No, no, this, no, this is a serious allegation and we have already filed the rejoinder to it, my lord. That will be heard on the marriage. my lord.
Prima facie, this court is of the view that we need further hearing in this matter, so we'll admit it. See, 85, forget about for the timing all this maintainability
Yes.
and all. If we go by that rule, 85, we'll have to, 85.
85.
3 and 4 conjoint. Because it's a panel.
Panel.
Now then we'll have to look into whether in choosing the panel, there are some criteria laid down in the act or rules, or whether that has been followed or not.
Exactly.
That will be the second issue. So prima facie, this court is of the view that select list having a number at select list 1 will not necessarily mean that it is a on recommendation on merit at number 1, or that merit in number 1 will have a vested right to be selected. Then this question would not have that panel. So panel means they have a further right to compare between these two persons and come to a conclusion. So that being the position, we are not
My
thinking
lord,
that this is having any very urgency.
My
So
lord-
give a date 4th of December.
My lord, panel, my lord, there is already comparative statement which also determines that who has got more experience. And as per the judgment.
No.
That selection is not even under challenge.
No,
That
no.
selection by the selection committee
No,
is not even under.
selection is not it's a selection of panels,
Yes.
minimum 2. Or
Minimum two.
maximum
Total
two. Huh?
Minimum
Total
two.
Total two. So that the appointing authority can have their own application of mind and choose one among them.
Now, question is that even they have not applied their mind, my lord. There is no any region.
therefore
They are
that-
saying that only
For
discretion,
that will require the record.
discretion and prerogative. That is the only.
Will require the record. Then you will have to show that even after mandate of law of a panel, you have a right over the other party, number 1, under what provisions of the
Exactly.
law,
Exactly.
not otherwise. Provisions of, not like a normal selection that you are a more meritorious. And other parties that they have a bounden duty under the act to act in a specific manner in doing this. That these are the two issues. Then the rest will think later on. Okay?
4th of December.
This matter, as the matter is ready as regards pleadings and service, issue rule returnable on 4th of December 2023. Full stop. Release this matter for here. No, as the parties are duly represented, no formal notice need be issued. Full stop. However, the Mr. Swenso learned government council shall keep the record pertaining to the selection in question ready on the date of hearing. List this matter for hearing on 4th of December 2023.
Obliged.
That is the issue.
That is, yes.
Why should you-
Wait, wait, wait. Also
So
suspension.
10, yes, what is it?
My lord, there are subsequent developments.
What are the development?
This inquiry is being conducted, my lord, carried out, my lord. Inquiry is being conducted, I admit. I was summoned on 10th, thereafter the witness has not been examined till then. Yes.
No, now suppose the search sheet is also filed.
Yes, my lord. Yes,
And in view of the amended rule, how many days you can put him under suspension?
270. 270.
270 days. That period is over. Statutorily, you cannot continue under
ma'am.
suspension.
I believe the 270 is 270 may not be over, not over.
Not applicable.
Not, no.
Here, what?
No, it's not. Yes, it's over, my lord.
Huh?
Yes, over. 22/11/2022. Yes.
Huh? 22.
Over. Yes. Suspension.
Huh?
Yes,
Because it
my
was
lord, yes.
suspended on 22/11.
Yes, man.
And now 20, on 22nd of 11, he will complete 365 days.
Yes, yes. Yes.
So
My lord,
today he has completed 276 days.
date of suspension and from the date of release, my lord.
Date
From
of
the
release,
release-
he was arrested.
Yes. my lord.
But you
No,
have.
no, I was
you-
not arrested.
No, this is not a
No,
case
no,
of
this is not
arrest.
arrested.
This is a so cause, suspension and so cause.
I was not arrested.
No, no.
Arrested.
Arrest is date of release and intimation. That also subsequently there are some judgments.
I was
also.
not arrested. Yes, yes, yes.
This is not an arrest. He was
Yes.
suspended on 22/11. Now it is, he statutorily you cannot keep
Yes.
him under suspension.
Yes.
That's all. We will not enter into the merit of this case.
Oh, yes, yes. I'm sorry.
Ah.
Other case, my lord.
Too many briefs.
APCS cases. APCS cases.
I've already dictated an order similar. So we'll upload it today. We'll
2011.
give it to Halit.
Date I can just
Not-
point out even now.
Ah.
Dates. The
Page
first
32.
First suspension date is 22/11/2022. Memorandum of charge was furnished on 13/1/2023.
We require 13/1/20. Okay, that we'll see.
My
That we'll
lord.
see. Here our ground is that statutorily you cannot
Yes,
keep
my
him
lord.
under
270.
suspension. Even if in case of filing of memorandum
Yes, my lord.
in
After
view of the new amendment.
Yes, yes. 270.
Disposal.
Obliged.
In Nathai Poriso. Yes. What is your instruction? Appeal.
This rig is also very new and it's all with problems. Lordship, appeal in fact, it was not decided, but they have said that the courts decide will abide by.
They will decide.
Now, if the court directs whatever.
Why they need our direction? It's a she has
Lordship,
having a
actually,
right. She
they
can raise in a first appellate court all the points. You can raise everything. We are giving you liberty. Already your demolished construction has started. So we'll say with a specific period, with a giving a personal hearing to you, they will dispose it of. Okay?
Until then, Your Honor, the
Construction we cannot say.
Construction-
See, madam, this is the issue. Suppose we hold today itself that you are entitled. Can we say that the public project should be stopped? They can very well tomorrow issue a notice to you. We can give them a permission to acquire the land.
Your Honor,
Is that it?
Yes. Your
So it is not a irreparable loss. Until and unless irreparable loss, there is no question of in giving injunction. You can be compensated in terms of money. Isn't that it?
Yes. Your Honor.
So therefore, stalling a public project when your title is clouded at this point. Isn't it?
Yes. Your Honor.
So better to have a decision taken there and come back here. If they goes against you, we'll decide that if you are entitled, you are entitled. If you are entitled, then you ask for compensation in a writ petition. You can very well do that. But can you stop a construction of a hospital? I do not think so.
Your Honor, however, the construction has taken place in furtherance of an illegal order. The order
That
that
we
was passed
understand.
is-
Suppose a person, you are having a property not disputed. admitted position.
Yes.
You are illegally removed therefrom with a removed therefrom, and thereafter you come to this court, and government takes a stand and say, okay, we have done a mistake. We are acquiring this land for this public project. Can you stop it? Can you stop it? We cannot stop it. So we have given even orders for compensation for this illegal demolition. In some cases, in fact, I have passed an order in
Even already demolished.
already demolished. And we say that you acquire for the already demolished purpose, we have given cost and compensation.
Yes.
So that we can very well do, but for that we cannot stop a public project. So therefore, we'll pass this order relegating the matter to the concerned deputy commissioner.
Yes, ma'am. However, it may be recorded in the order that they have passed the order in violation of the Arunachal Public.
No, we
Services
cannot
Act.
come to a conclusion. We'll say that all the points raised in this petition regarding violation of the provision of the Arunachal Pradesh Public Premises Eviction Occupancy Act 2003 can be taken, and all other grounds be allowed to be taken by the appellant. And the deputy commissioner appellate authority shall pass a reasoned order on all the questions of law and facts raised.
As soon as possible, Your Honor. then
We'll
in
give
that
a
case,
specific
short-
date. Okay, heard Ms. T.Y. Bhutia, learned counsel for the petitioner. Also heard so-and-so, learned counsel representing the respondent authorities.
And I'm for respondent 3.
The case of the petitioner is that his residential house in Liru village, Likabali, Lower Siang district, Arunachal Pradesh, has been demolished by the impugn notices pursuant to impugn notices dated 17/4/2023, 19/5/2023, and 31/5/2023. Now, who is the state officer? Who issued the notice?
The Deputy Commissioner.
He is the state officer.
Usually the government appoints the state officer.
How can he act as an state officer? Who is the appellate authority?
DC would be the appellate authority.
Then how can he, who is the authority under the act? Who is the state official? Because if you exercise your power under Arunachal Pradesh Public Premises Eviction Unauthorized Occupancy Act 2003, then it should be issued by an state officer. Who is the state officer? You cannot be the appellate authority. What will you decide? You have already issued notice.
ADC is the state officer apparently. ADC is the state officer, I've been informed.
ADC or some extra assistant commissioner?
Yes, EAC, extra assistant commissioner and additional deputy commissioner, they used to be the state officer.
If state officer.
Yes.
Now, here the notice is issued by the deputy commissioner.
Yes, madam.
Then in that case, it is
Huh?
outside of the
First
office
notice
jurisdiction.
issued by EAC for deputy commissioner.
How can it treat it for the deputy commissioner? Deputy commissioner itself is an appellate authority. So whole thing will go. And will give a liberty to her to establish her title before a civil court. Because already land has been acquired, and if you want to acquire, yes, we will hear this matter day after tomorrow. Tomorrow. Tomorrow is Wednesday, Thursday, we'll hear this matter on Thursday. The deputy commissioner cannot, if you have violated the provisions of the act, we'll stay everything. We'll set aside everything. You cannot do like this. I thought that it was the state officer, now appeal is pending, let that forum not be ignored. But how can deputy commissioner decide? He himself is a person whose order is being challenged. He cannot be the prosecutor and judge himself. Yes, okay, come prepared. We'll decide this matter on Thursday itself.
And I'm prepared today as well.
No, not
So-
today. We have some other works today. That's why we have not taken up this matter. Day after tomorrow, as agreed to by the learned council, whatever it is, day after tomorrow. An endeavor shall be made to dispose of the matter. Be prepared. See who is the authority and who has issued on whose behalf, and whether it's in this way, a right of appeal, this will be a futile exercise now. So we'll have no alternative but to take up this matter and decide on merit, though appeal is not done. If she is not having an alternative and efficacious remedy in view of your action, we'll decide the matter. You be ready. Yes.
Your lordship, I may be given some more time to file our counter affidavit. I may be allowed to give some more time to file the affidavit in opposition, your lordship.
The learned counsel for the petitioner, respondent state praise for and is granted
3 weeks time.
3 weeks time to file counter. First of interim order pass earlier shall continue till then. List accordingly, tarpisod dibo interim order pass earlier shall continue to
Oblige, your lordship.
Most obliged.
Yes. Driver scale of pay.
My lordship.
Affidavit.
My lord, we need
When?
some more time, my lord. We
Why
have
are you-
received for respondent number 4, we have received, my lord.
Sorry to inform, lordship, I have furnished only one copy of extra copy, lordship.
Huh?
I
We
have,
have furnished only one copy, my lord.
Okay.
So that.
Learned counsel for the petitioner shall furnish extra copies to the learned counsel for the respondent number. Council, state council. Okay. List this matter after
4 weeks, my lord.
4 weeks. In the meantime, the respondent state shall file their counter affidavits. List, list accordingly. Yes, yes, here is also no
Please.
affidavit.
Please, my lord. My lord, there are similar matter pending before this honorable court. So I request this honorable court to taken up together. This matter. Otherwise, they have not filed a reply.
In other cases also not filed.
Yes, otherwise.
Yes, yes,
And the-
termination.
WPC, my lord, WPC
The
398,
learned
400,
counsel for the
401.
petitioner submits that similar matters are pending for adjudication before this court being
Being WPC 398, 400, 401.
all 2023,
Correct.
2023.
This will be taken together.
Accordingly, he prays that the present petition may also be taken up along with the aforesaid petitions. Prayer is allowed, list this matter after 3 weeks.
After
In the meantime, the state council shall file their counter.
Oblige.
Okay. Harvish is ready. You are for respondent number?
Malad, I'm for respond number, Malad. 6, Malad. Here, Malad. The
What is this IA, WPC?
IA, Malad, this is what happened, Malad. The writ petition was filed for cancellation of the tender and re-tender, Malad. Now subsequently, that tender has been cancelled. Now thereafter, after cancellation, they have withdrawn the writ petition on instruction. Now thereafter, they with dismissal on withdrawal, they filed this IA praying for restoration of the disposal, the dismissal order on withdrawal. And wherein
What is the ground?
Your lordship,
What about the contract work?
Contrary work, my lord, this earlier tender that has been cancelled, my lord.
So their challenge was to that tender
Yes,
which
that-
has already
that
been
gone, my lord.
cancelled.
That has gone, my lord.
Now
That
what
has
do you
survived.
want?
Lordship, my humble prayer is only for
To
today.
dismiss this?
Though this matter is become infrastructure. but,
Okay,
uh,
that should be your humble prayer, humblest prayer.
But Lordship, we may allow to let this miscase will be restored. And the main petition will discuss on
Because
merits.
some shadows, some thoughts are above your head. What is that order?
Page 13. Page 13 of the IAL.
So you'll say that this repetition itself was became infructuous. So therefore nothing survives in this petition. That much we'll say. Okay. The present application is filed for recalling of order dated 7/8/2019. Full stop. 2019 passed in WPC 299 within bracket AP 2018, page 13. Page 13, Silo. I missed case of page 13. Full stop. The aforesaid writ petition was dismissed for non-prosecution by the aforesaid order on the background facts that the learned counsel for the petitioner submitted on instruction that the petitioner is not interested to pursue the writ petition any further. Full stop. The WPC 299 AP 2018 was preferred assailing and tender process, assailing and tender notice tender notice from amongst with prayers amongst other to cancel work order if any awarded to the respondent number 9 and to initiate retendering process in terms of the NIT dated. Nothing is there in this writ petition. No NIT, nothing. Huh? Why should we dictate all this order? Which was under challenge? 23/3/2017, is that it? Or no?
Lordship, it's 2023.
Nothing was challenged. You cannot, nothing was challenged in this writ petition. If any ifs and buts, it order लिखो. प्रथम किन लिख लेना. Dispose of so and so. Full stop. This court is of the view that such order cannot be recalled and a writ petition cannot be restored by way of a miscase. Accordingly, the present IS stands closed. It is also submitted that the tender process which was under challenge and cancellation was which were sought for in the original writ petition was also cancelled, and accordingly the writ petition itself became infructuous. It itself became disastrous. Considering the all above, this court finds this closes this IA. Nothing is there. I thought that some not even a prayer which NIT under what, nothing is there. Rightly you have withdrawn this case at that point of time. Yes.
My lordship.
Rejoinder.
My lordship, this matter may be listed along with one WPC, lordship.
No, will you file rejoin that tell us first or not file?
My lord, actually, I was thinking to give a different proposal, my lord. Now, my lord, here is a case, my lord. It was a tri-party. That out of tri-party, 90% affected people they have accepted. Only the 10% they are not agree to that. If my friends, my lord, agrees to that, my lord, this can be disposed of, my lord. If the amount which was settled by the tri-party, my lord. Because 90% they have agreed, only the 10% they are hesitating. What they are making a prayer, my lord. My lord, with my lord objection, they are ready to accept this, my lord, the amount, my lord. So the in due course they can agitate before any appropriate forum. That's what executive prayer, my lord. Double, my lord.
My lordship, it may be listed along with lordship, with petition 403 of 2021. After a week, lordship.
Okay, on the prayer of the learned council for the petitioner, release this matter after a week.
No issue.
Lordship, we are yet to find reply here.
What to do? Tell us.
Awaiting swearing of the ready.
Okay. The learned state council submits that the affidavit is ready and could be filed within a period of a week from today.
Yes, Lord.
Okay. Accordingly, she prays for an answerment. Prayer is allowed. List after a week.
3
In
weeks,
the
Lordship.
meantime, the affidavit may be filed.
After 3 weeks, Lordship.
Why your affidavit is ready?
Lordship, private respondents services also awaiting.
Okay. In the meantime, affidavit may be filed. Answer notice in respondent number 5. What will you do?
For next time, next date may be given.
Okay. The learned counsel for the petitioner prays that he may be allowed to take fresh steps upon respondent number 5. Prayer is allowed. Full stop. Such steps be taken within a period of 5 days from today. Full stop. The notice upon respondent number 5 is made returnable after 4 weeks. Full stop. In the meantime, the registry shall put a note as regard service of notice upon respondent numbers 3, 4, 7, 10, 11, 12, 13, 15, 17, 18, 19, 22, and 22 to 2025. List after 4 weeks.
Nice.
My lordship, sorry to inform you that lordship, I have not taken the dusty service upon the respondent
Number
8, 9, 14, and 16, lordship. What week time may be, lordship?
My lord, before my lord, there is something technical issue is there. There is a latches on our part also. When your lordship see the my lord, impugned order, the impugned order was passed based on the course directive, my lord. And in that course directive, the present petition, he was also one of the respondent, my lord. If lordship see that, my lord, impugned order, my lord. That's why I've said, my lord, there is latches on our part also. We could have pointed out on that very moment, my lord. Whether in this form, this petition can be maintained or not.
Now, impugned order is page 79.
That reversal order, my lord.
That is 22nd August 2022.
Yes,
Consequent upon judgment and
Yes.
order 26th and 20 passed by this court. Obidai and 9
correct.
others.
Correct, my lord. That is the impugned order, my lord.
He is Ama Palo.
Amapal. In that Obidai, my lord, he was also one of the respondent, my lord.
Where is the judgment? Page 104. No appeal preferred.
From
My lord,
47.
appeal
lordship.
preferred because
Appeal
my lord,
preferred.
there is a delay, my lord. The delay is yet to be condoned, my lord. So appeal is also not admitted, my lord.
Okay.
So that is the some technical issues are there. I think it is my duty to point it out, my lord.
Yes, Amapalo, respondent number 7.
7, Lordship.
It was set aside. Any stay in this case?
Yes, sir.
Yes, Father.
Stay.
That's why I'm saying, let's just put a part of it pointed out.
How can there be stay?
Well, Lordship. Lordship, method may fix after a week, Lordship. Due
Now
to
you
some,
said that there is a submission that 3/11 of 2021, there was a stay.
yes, sir. Emi, Lordship, respondent number
But
6.
but that judgment is stayed.
Yes, sir.
Yes.
The single bed judgment has been stayed.
Okay, when you are taking advantage of your delay.
After a week, Lordship. After a week.
Okay. But there is a stay in that, or judgment is stayed, maybe by respondent number 6,
Yes.
but judgment is stayed.
This is no doubt.
Uh,
The present petitioner.
But even suppose the contempt, suppose a contempt is filed by the petitioner, then also contempt cannot proceed because there is a say, it says judgment in respect of though two. Anyway, if you take steps, in fact, you should insist on the hearing of the writ appeal. Then everything will be over. No, you get that other one hard. Forget about him.
I think,
That should be hard.
that should be hard.
Okay, on the prayer of the learned counsel for the petitioner, week's time is granted to take dusty service. Dusty service in terms of this court's order dated
26/7,
26/7,
2023, Lordship.
2023.
2023.
Full stop. 2023. Such steps be taken within a period of 5 days from today, and notice is made returnable on give a date. After 4 is give a date. Huh? 18th of December 2023. Full stop. The petitioner to file an affidavit in proof of to the registry. Full stop. The interim order passed earlier shall continue. Interim order dated 8/9/2022 passed earlier shall continue subject to taking of steps through dusty as directed today. Otherwise, it will get vacated. It cannot be. You will take a stay and not take dusty service.
All right.
IA has been filed for implement of the party, my lord. Respondent number 2 is retired, my lord. In place of respondent number 2, new incumbent has joined, my lord.
Have you intimated?
Yes, my lord.
Have you intimated him, respondent number 2?
Yes, my lord.
Okay. The present application is filed for implement of the present director, Neris, Arunachal Pradesh, as respondent number.
In place of respondent number 2.
How in place?
We have respondent number 5.
Who is representing? You are representing.
Since this is a content matter, notice may be issued. because
No, notice will issue. Who is representing the earlier respondent? Respondent number 2.
3 and 4 I'm representing.
Who was representing earlier item number?
Earlier, same was not represented.
Okay. Comma, in place of respondent number 2. It is the case of the petitioner that the respondent number 2, Sri H.S. Jadhav, the deed and director Nirjuli, Arunachal Pradesh, has in the meantime retired from service, and on his retirement, after his retirement, a notice was issued to Dr. Narendra Nath S, Director Nirjuli, by the petitioner on 4/9/2023. (29) 4/9/2023. First of, however, it is stated that even after receipt of such notice, no action has been taken for compliance of the judgment or order dated 9/12/2012 passed in WPC number 470 within bracket AP to 2011. Full stop. Peruse the pleadings as well as the notice dated
4/9.
what date is it? 4/9/2023. Full stop. Accordingly, this court is of the view that the said person, the present directors, not said person, the present director, namely
Dr. Narendra.
Dr. Narendra Nath S.
Yes.
Narendra Nath S. be made as made as party respondent number 2 in place of
Respondent number 5.
respondent number
In place of, now he will be respondent number 5.
be implemented as respondent number 5 in the contempt petition. Full stop. IA stands closed. Target number registry to correct the cause title in the contempt case and list the same after correction. Full stop. Then only we can issue notice in the contempt, not here. IA stands disposed of. Yes.
Mayor, please. Also, the main counsel is not able to come today because of his personal problem at home. So, as per the last order, we have taken the justice service for respondent number 3, 4, and 5.
Okay. Have you filed affidavit?
Lordship, we are supposed to file affidavit today because
Okay, file it.
And your lordship, extra copies has not been furnished.
You are
to
for the
us.
state?
Yes, your lordship.
Okay.
Respondent number 2, your lordship.
Respondent number 2. Is submitted by the learned counsel for the petitioner that pursuant to order dated 23/8/2023, the service of notice upon respondent number 3, 4, and 5 were effected through the stick. However, he may be granted some time to file an affidavit in proof thereof. Full stop. Prayer is allowed. Full stop. The petitioner is also to furnish extra copies of the writ petition to the learned state council representing the respondent number 2, Deputy Commissioner, Sanglang, within a period of 3 days from today. List after 4 weeks. In the meantime, the respondent number 2 may file
Lordship,
affidavit.
stay may be continued.
Interim order passed earlier shall continue till the next date of listing. Full stop. List this matter on give a date. No, in the meantime, file an affidavit and bring on those on record that how you have served the notice, in presence of whom, whether that is their signature. We'll have to state from then only we can accept the service.
Yes. Okay.
On 28th of December. You file that, then it will come to you.
24.
Yes, what is this?
May I, Lordship? Lordship, the main counsel of the petitioner is not available, so kindly this matter may be listed after 1 week.
This is regarding claiming of compensation of the patient who died in 2015, in the district hospital, Roing, there was no negligence as such, He was a manic patient, Because of Emenik, he died, my lord. Now there's allegation that because of there's a non-availability of blood bank.
They have filed your affidavit. and-
Yes, we have filed it, my lord.
Okay, on the prayer of learned counsel for the petitioner, let this matter be listed for hearing next week, in the next week.
Obliged, my lord.
Huh?